today you're going to hear a bit of a double act or a triple act. So you'll hear from me, Head of Employment at Actons, but we're really pleased to be partnering with the guys at OTB Legal. So Sally and Lydia will be updating us on some immigration law info. That'll be towards the end of the session, so do stick around for that. But the bulk of the session, I guess the beginning, will cover the Employment Rights Bill. So it's an employment law update on that, and we're going to be talking about what's coming down the tracks in employment law first of all. So for those of you that don't know me and Actons, I head the team at Actons. We're based out of Nottingham, working with SME businesses, employers predominantly, and a number of household names. Number of you are on the call, so great to see you. And yeah, we cover the full range of employment law that you might expect, through from contracts, handbooks, absence management, TUPE, employment tribunals, that kind of stuff. And yeah, we're busy at the minute, unsurprisingly. Lots of change coming and lots of good stuff going on. The team is there, and do connect with them on LinkedIn. And I should say, there's lots and lots of stuff changing. We're doing lots of these sessions. LinkedIn is a great place to follow us and connect with us there to keep up to date on what's happening. So do scan the QR codes there. I share almost daily updates and posts on various things, including lots of this stuff. And lots of it is changing almost week by week in terms of little announcements that come out, or in fact, like happened just this week, a complete update to the Employment Rights Bill following the committee stage of that passing through Parliament, which was difficult timing for me and this session this morning. But we're going to crack on and pick up some of that. It's potentially going to change again, so I'm not going to major on many of the changes that have taken place this week, partly because I'm still working through the extra 40 pages on the however long the document was previously. But yeah, the headlines of where we're going with this stuff is the key, so that you can start planning ahead. So we're going to look at what's in the bill, what's not in the bill, and that actually has been quite interesting, because there was lots of noise about what might be coming prior to Labour being elected and during the first sort of 100 days of their tenure. But actually the stuff that initially wasn't in, some of it's snuck in and some of it is being dealt with other ways. So we're going to look at some of that stuff too. We're going to look at timescales for lots of this, and also as we go, trying to be practical about what we might need to be considering now. And again, there's lots of people sort of trading off the back of, you must do this now, you must change this now, you must, look at these things. I think actually the headline is we've got plenty of time. So most of this stuff is unlikely to kick in until next year, actually, so 2026. But we do need to be thinking about the direction of travel, because it will be important to plan ahead. And the starting point, I guess, is the bill itself. So you hopefully can see the front page there. I haven't included all of them because there's now, well, even more of it as of this week. And also the government's next steps to make work pay document, which actually, if you're going to read anything, I wouldn't recommend reading the bill, because it's very, very painful and in fact refers to other legislation. You have to cross-reference a whole load of things. But actually that red covered document with a lady hanging from a building or something like that will give you the headlines of what the government are trying to achieve with the bill. And I think, yeah, it's a much more accessible read if you would like to get into some of that detail. It's actually a little while now since the bill was released, so October 24, and the stated objective is to support employers and businesses across the country, create a level playing field for employees, and modernize employment rights. And I think the government have talked about the fact, and a number of commentators are, agreeing that actually it's probably the most fundamental change to employment rights, to employment law in at least a decade. So some of this stuff is pretty significant, and will have an impact on the way that we have to manage employment situations generally. So it is a big deal, and lots of people are grappling with how this is going to work in future, and hopefully today will be useful in terms of your planning. So straight into the topics. Unfair dismissal day one rights, I guess, is the one that most people have heard of. There's probably been the most noise about this one. And essentially what it does is remove the 2-year qualifying service. So the fact that you have to be employed for 2 years to claim unfair dismissal at the minute, and introduce that concept of, or protection from, unfair dismissal from day one. That said, the bill makes it subject to what's called an initial period of employment, or sometimes now being shortened to IPE. And that's a new concept. It's not a probation period, but it's similar to the idea of a probation period, where there's a period at the beginning of the person's employment where a light touch dismissal process or procedure will be applicable, and it will be easier, as in there'll be less process to follow and probably less reasoning given to the employee as to why they're being let go during that period of time. You'll see from the slide that we're talking about detail to follow in the regulations. Now, actually, we don't have all the detail as to how this will work yet. And regulations, it's probably worth me explaining, because this will come up a little bit as we go, are effectively kind of secondary legislation that the government can introduce to fill in the gaps in the bill. And to be honest with you, there are lots of gaps in the bill, and there are lots of areas where they say it will be subject to regulations, and the government will release that detail in regulations, which are much more easily put in place further down the tracks. But we have the kind of overall framework now in the bill. So that's why with some of this, we're still missing some detail. There's been some discussion, some indication from the government as to what that initial period of employment will be, so how long that will run for. There's talk of it being between 3 and 9 months. The I think next steps document suggests it could be 9 months. There's a suggestion that it could be a 6-month probation period plus 3 months notice, and that's effectively why there's the 9-month concept. But we'll see where they land with that. As I say, the bill is changing as it moves through Parliament, and it may well be that that's one of the key things that will change, on the basis that it's such a fundamental part of all of this. As I said earlier, it's not strictly speaking a probation period, though it may be that actually one of the things that you'll want to look at is whether your probation period should match the initial period of employment that's introduced as this new concept moving forward, so that they marry up. And I can see some issues where there's a kind of a difference between those two, and how that will interact as we go forward. As I said, there will likely be a different dismissal procedure during that time, but also a different compensation regime, as in if someone brings a claim during that because they think that bit's been done unfairly during that initial period of employment, the compensation regime is likely to be different to normal unfair dismissal. So again, that will throw up some different issues for us, I think. What do we do now when it comes to the unfair dismissal day one rights? Well, you might actually want to look at your contracts. You might want to decide whether, well, check out whether you have probation periods at the minute. I think most people are taking the view that because there's going to be this new concept of initial periods of employment, if you don't operate probation periods at the minute, you're probably going to be doing that effectively by having to follow this initial period of employment, and you might want that in your contract. But being aware of what kind of length of probation periods you have in contracts at the minute is a good idea. Supporting managers when it comes to performance management, I think, is going to become increasingly important, because actually if these day one rights apply, it won't be so easy just to exit people from your organization, particularly on performance grounds. And actually managers being better trained on performance management and knowing how to do that well will be increasingly important. And of course, there's no reason why you couldn't be doing that now, and getting them ready for this change. And then this change of mindsets point, I think, is an important one, because in a lot of businesses, the 2-year mark has become a thing. It's okay, we can let people go quite easily before the 2-year mark, and therefore we don't need to worry about whether they're doing okay, whether we actually need them, and that kind of thing. And I think getting out of that way of thinking, changing that mindset, particularly with managers, will be really important moving forward. So that's going to be a key factor in this at the point it's introduced. They have indicated that they think this is most likely autumn of 26. So actually on that front, we do have quite some time. But I think that's, I suspect, because it's one of the most fundamental changes that we're going to see. 0 hours contracts. So again, another area that hits the press fairly regularly over the last few years in terms of people's perception of these kind of contracts. I think the reality is that the press and I guess Labour have fueled this, the government have fueled this to a certain extent, aren't particularly keen on 0 hours contracts, and they've been demonized, I guess, to a certain extent, because of the perception that they're kind of abusive to workers. I think the flip side of that is that some workers choose to work under 0 hours contracts because they like the flexibility, and as long as they're not prevented from working elsewhere, if the work's not available at one employer, they can provide a good flexible way of working for employees, and certainly they're beneficial to employers who need to sort of turn off and on the tap when it comes to the people resource that they need. But there are some fairly fundamental changes coming in the bill in this area. There was talk about them being banned altogether. That's not the case, but I think the use of them will be restricted by this. There are a number of areas, and again, the detail on this is lacking, but it's also very complicated in the bill. So people are still trying to get their head around exactly how it will work, partly because there's an absence of information and partly just because it's really complicated. But what we do know is that the previous legislation that was due to come into force in this area won't, and it will be replaced by the Employment Rights Bill provisions there. And essentially, there are 3 areas that we'll look at where this legislation will change the position with 0 hours contracts. The other thing I should mention before we look at those 3 things is that they're also consulting about whether this legislation will apply to agency workers. And that's obviously a different arrangement to 0 hours contracts. But again, there's the suggestion that they'll want to look at that and tighten things up on the use of agency workers. So the areas that they're looking at in terms of how this new regime will work. The first of those is around the right for a worker to be offered a guaranteed hours contract. So essentially a fixed contract that guarantees them the hours that they have been working over a reference period previously. And again, this is designed to give some certainty to the individual. The tricky bit with this area is at the minute we don't know what that reference period would be and will be. The suggestion is that it might be a 12-week period. So you look back 12 weeks and say, okay, these are the hours that the person's been working. This is now the contract that they're going to be offered. And the way it would work is that the employer is then obliged to offer them those hours. The worker then has the ability to decline or accept that offer during a response period. But again, we don't know how long that response period will be. And essentially that contract must be on the same or more favorable terms. So that would be an option for the employee to then say, yes, I'd like, or sorry, the worker to then say, I'd like that contract, please, or in fact to decline it and say, I'm really happy on the flexible setup that I have. The other bit that they've set out is the right to reasonable notice of a shift. So designed to ensure that workers have visibility on the work that they're going to be asked to do. Again, at this point, the information is not great. It's not entirely clear what reasonable notice of a shift would be. And then there's a really complicated provisions around compensation for breaching this provision. So if an employer doesn't give reasonable notice, what they would have to pay to the worker if they hadn't complied with their obligations. And our guess is that that will be something like if the employee or the worker can't work the shift because they weren't given reasonable notice, then it's the some amount to compensate them for that. Likewise, and I suspect probably more likely to happen more often, is cancellation of a shift. So where an employer says, well, actually, yes, we had rotated you to do this shift, but actually we don't need you to do that anymore. And again, there'll be a right to be paid if they're not given sufficient notice of that cancellation. We're not sure what reasonable notice will be. And the gist of it is that it's designed to penalise employers for cancelling at the last minute. But as you can see from the slides, we're still missing lots of information on that front. But it will make it more difficult, I think, for employers to operate 0 hours contracts, which of course is likely the stated aim of this. And it will take some navigating for employers to work through this and do it well and still operate these kinds of contracts. Again, some have suggested that it might result in people moving to agency workers for more flexible resource, but again, the consultation suggesting that they might be looking to tighten up in that area at some point too. So we'll watch this space on that one. Jumping again, because the bill covers so many different things, to a slightly different area, family rights. There are a variety of areas where the bill covers what we're describing as family rights. So there's additional protection for maternity returners from dismissal. There's day one rights to bereavement leave and parental leave, and some paternity leave changes. We're not going to go into the detail of those, but again, the direction of travel is very much let's look after the workers on these things. And yeah, essentially extending, particularly the various leave that are listed there, extending the ability to take those leaves to people from the point at which they start employment is the gist of those. Flexible working, another big one. Lots and lots of press coverage, both in the HR press and the general press, about how flexible working might work. The whole post-COVID world of hybrid working. Many of you may have spotted the panorama on the working from home issue recently. It continues to be a hot topic in the world of work, and I suppose it's probably one of the most, in my opinion, underwhelming provisions in the bill, given the amount of sort of fuss and the amount of noise there was about what might be coming in the bill. And I think it's probably worth just having a quick reminder as to the current law on flexible working. So essentially at the minute, employees can request changes to their working arrangements twice a year. The employer has to deal with it in a reasonable manner and can refuse it for one of 8, or I think it's one or more of 8 grounds that are set out in the legislation. And the employer has to tell them which ground. They don't really have to give much more detail than that, but they just have to say it's because of this. And that has been the case for a reasonable amount of time. There were some tweaks to it recently in terms of 2 requests being allowed and that kind of thing. The changes that are proposed don't actually strike me as particularly significant, because all that's really changing is that the employer can only refuse the request if it's reasonable to do so. That's very similar to what we had before. And they have to explain their reason for refusal and why it's reasonable to refuse the request. So essentially, it's about giving more information as to why you're not prepared to accept the request. And there is some stuff in the bill which suggests you might have to talk to the employee a bit more about those things as you go through the process, but the 8 grounds remain the same, and there's no change to the penalties for breaching this either. So it doesn't feel like it's that significant, given the government's sort of stated aims of supporting workers to be able to work more flexibly. But I suspect it might result in more flexible working requests, but employers, I don't think they actually have to do too much more to deal with those. The other thing that may have caught your attention already is changes to statutory sick pay, and effectively it's a proposal to remove the waiting days ahead of being entitled to statutory sick pay. That would mean that SSPs due from day one of sickness. The proposal is also to remove the lower earnings threshold, so it will extend the coverage, I suppose, the entitlement of SSP to a wider group of people. And essentially, it's going to cost employers more because more people will be entitled to SSP more regularly. I think there'll be some interesting interactions at the point it kicks in with how employers run their occupational or company sick pay if people pay over and above SSP. And as the slides suggest, there isn't any proposal to make SSP recoverable from the government, surprise, surprise, as used to be the case many years ago for those that are old enough like me to remember when that was a thing. So that's an additional cost to employers, which, of course, combined with the budget and national minimum wage and national insurance and that kind of thing, many businesses are not particularly happy about. But again, it's designed to support people while they're sick. Fire and rehire, again, is getting a bit more attention now. I think lots of our clients were not that concerned by it because they would regularly say to us, well, we don't do fire and rehire, Nick, we don't need to worry about that. And actually, I think the challenge with this is that fire and rehire is essentially the end point of an exercise where you are changing terms and conditions, and most employers change terms and conditions for their employees at some point or like the option of doing that. And fire and rehire is the proposals are likely to make that very difficult, if not impossible. And the knock-on impact of that is that it will make changing T's and C's quite tricky too. So let's look at how this works. So current law is that where you're dismissing an employee who refuses to accept a change to their terms and conditions, it can be potentially fair. So that's, like I was saying, the kind of the end point, the nuclear option, as I often talk to clients about it. We'd like to change this. We have a good business reason for making this change. We're going to take you through a period of consultation, and we would like to for you to agree this change. If you don't, it might be the case that we have to dismiss you and offer you the new contract with the term that's changed, everything else being the same, but that key term that we were looking to change, offer that again. It's often called dismissal and re-engagement as well as fire and rehire. And essentially, you need that sound business reason, you need to follow a fair procedure, and you need to show that it was reasonable, and that's possible to do. And actually, a lot of employers run those kind of processes, both where they're looking to harmonize terms across a workforce, or often where actually they need to make those changes in order to keep the business afloat. So it's often, an important thing to be able to do. The proposal is that this legislation would end the ability to do that, and that it would effectively be automatically unfair to dismiss an employee where they refuse to agree a variation of the contract, so that the change to the T's and C's, or where you're looking to replace them with another employee who would agree to work under the new terms. So effectively dismiss them and replace them with somebody else who was prepared to work under that. The one exception, and I think most people are taking the view that it's a very limited exception, is where the business is in such financial difficulty that it was necessary to do this. But of course, I'm sure you would agree, most business owners would prefer not to take their business to the absolute brink before making these kind of changes. If that's the only way it's possible to do, they'll no doubt try and find another way of dealing with it. I think the suggestion in a number of quarters, and I think our view might be slightly biased by the fact that we work predominantly with employers, but the suggestion is that it may be going too far, particularly when you think about some of the scenarios that where this process might be followed that aren't really about doing employees out of work or reducing their pay or that kind of thing, but it can be scenarios where actually you want to change people's hours because you need to introduce more work into the organization, perhaps new shift patterns where actually you've been able to extend the hours that your factory operate. and you need 3 shifts instead of 2, and actually you just want to tweak hours slightly so that you can run those 3 shifts across the day. So it's that kind of thing where actually that could potentially be quite a positive thing for the business and for the employees overall, but it won't be possible to kind of force those changes to working patterns in that scenario. And then the other thing that's suggested is that people who were dismissed for failing to agree these kind of changes would then be able to have access to something called interim relief. And I'll just very quickly try and explain what that is. At the minute, it applies to whistleblowing claims where somebody says they're dismissed because of the fact that they've blown the whistle, and it allows them to go to the employment tribunal within 7 days of their dismissal, and then usually within another 7 days have a hearing to decide whether it was likely that they were dismissed because of the whistleblowing. And the suggestion would be here that they would be able to do the same thing if it was a fire and rehire situation. And of course, that's pretty significant for employers who within the space of 10 days to 14 days could end up with a tribunal hearing. And anybody who knows anything about the tribunal system at the minute knows that it's taking years as opposed to weeks. So it's quite a different thing. But the outcome from that hearing, if it's decided by the tribunal that that person was dismissed because either they blew the whistle or in this case there was a fire and rehire situation, is that the employer has to pay that person's salary and benefits until the final hearing, which could be a year, 2 years in advance, and there's no reason that they have to pay that back if they then lose at the final hearing. So it's pretty significant. We had one of these cases for a whistleblowing situation in the team just last week, which we successfully defended, which was good for the employer. But that could be quite a significant thing in itself. I think the proposal is that would apply to another area, which we'll come on to in a second. What could we do instead, given that this fire and rehire situation is coming? Well, we could look at contractual variation clauses in contracts, so the ability to change terms by virtue of that flexibility that's built into the contract already. The challenge there is that you would probably need a clause that allowed you to vary every single individual term. That would be unworkable. And actually the variation clauses, the case law on that tends to be suggesting that doesn't really work very well, because just having that carte blanche ability to change employees' terms and conditions isn't really perceived as a good thing. The other thing that I think is likely to happen is that rather than fire and rehire, we'll end up with just fire. So employers will more regularly just be running redundancy processes as opposed to trying to change terms and conditions. And it might well be that actually, again, this pushes people towards using a more flexible resource like agency workers, where they're not recruiting them to do the same thing on the same terms because it's a different arrangement. So certainly what I would be suggesting for you as employers now is looking at your terms and conditions and thinking, is there anything that we might want to change? Is there anything that we've always thought, we should probably look at that at some point? I think now would be the time to start that process, and we're helping clients at the minute with those processes to make sure that the consultation is right and the business cases are right for doing that. Because if this change does come, and it looks likely, then it will be more difficult to do that in the future. Collective redundancy consultation, another change was through this. This is a situation where an employer is proposing to dismiss as redundant 20 or more employees, and currently the law says, as is underlined there, at one establishment. So that usually means at one site within a 90-day period. The change here, and again, those of you that have been around long enough will remember when this wasn't a thing, and this was as a result of the Ethel Austin and Woolworths case. They were a high street store, for those of you that aren't old enough to remember either. And essentially, this case was around whether one store in the UK was an establishment, and whether Woolworths had to consult just at the individual establishments, the stores, or across the entire workforce, in the UK. And essentially, it was decided that it should be just at each store that you look at the 20 or more. So essentially, if you were making less than 20 redundant in one of those sites, then actually you didn't have to do collective consultation with representatives and follow a much more heavy duty process. The proposal here is that at one establishment piece be removed, And that will then mean that employers need to keep account of redundancies across their entire workforce, whether it be in Plymouth or Aberdeen. And that the numbers that are made redundant within that timescale will need to be taken into account when it comes to collective consultation obligations. The theory being, I think, again, from the government, that they take the view that collective consultation is a good idea. Now, it is more work for employers. I don't necessarily think it's that bad an idea, on the basis that my experience is that actually, if you've talked to reps about the situation, they're involved in the process, helping disseminate information. That can be quite helpful ahead of then having to do individual consultation with employees anyway. But yeah, that change is likely to come. Union rights, again, unsurprisingly, the Labour government were quite hot on improving the position of unions in the bill. It will repeal the vast majority of the legislation relating to unions that the Conservative government put in place, which made things more difficult for unions. And the gist of it, and again, there's stacks and stacks of detail on this, which we're not going to look at because we don't have time today, but essentially it will give workers a right to a statement of trade union rights. It will allow unions to have additional rights to access workplaces, and it will provide additional protection against detriment dismissals for taking industrial action. So the gist of it, as you'll have picked up, is to make it easier for people to join unions and for unions to operate in workplaces. It'll also make it easier for unions to get recognition, and there's various thresholds there. Again, you can read it from the slide. I'm not going to talk you through it necessarily, but it will make it easier. The thresholds are effectively lower for unions to get recognised, as is the thresholds for strike action and that kind of thing. So I think if you already operate in a unionised environment, there probably won't be that much to change. But I think the fact that unions may well be looking at your workplace and thinking, oh yeah, that could be somewhere where we could get some traction, get a foothold. It might be that that's something you need to consider. And as I say, if you do have a unionized environment, they're likely to be saying, okay, well, we have enhanced rights now to operate more freely in the workplace. Third-party harassment, and again, there's been a fair bit of confusion in this area, and my first slide on this just seeks to clarify the position. There's lots of talk over the last few months, mainly because of the changes that came into place last October about harassment generally, and I think people are starting to get a bit confused about what's what. So hopefully this will clarify to a certain extent. There are different ways that an employee can pursue harassment if they're subjected to it, and there's different grounds on which they can do that. The first one there listed is a harassment claim under the Equality Act, and that's existed for quite some time, and it can be on any of the protected characteristics. So it's not just sexual harassment. It can be the full range of protected characteristics that we would associate with discrimination. Then in October, there was a new duty to prevent sexual harassment that applies to employers. That again got lots of attention, and lots of people were saying you need to do training and this kind of thing, and that's the case. But it's different from the harassment claim at the first bullet point there. It also doesn't give, that second bullet point doesn't give an employee the right to bring a claim against their employer. That's more of a Equality and Human Rights Commission issue, as in they can investigate if there's a complaint made. And then there's something completely different, which is a harassment claim under the Protection from Harassment Act, which is very different and very rare, which again we're not going to talk about. But again, it's an option for employees who are looking at this area. So the third-party harassment that we're about to talk about is something different again, and that is a duty which would come in as part of this bill, where an employer has to take all reasonable steps to prevent harassment by a third party. So that would be your customers, suppliers, clients. It imposes this direct liability on employers that haven't complied with the duty. It's applicable to all employers, but there will be consideration as to the size of the employer, and obviously bigger employers with more resource will likely be held to a higher standard, I guess. And the challenge with this, of course, is that it's harassment by third parties that you don't control in the same way as your workers. And I think that's part of the concern that employers have about this, particularly in hospitality, leisure, that kind of thing, where actually the general public are interacting with your people on a much more regular basis. And having been seen to take the steps that you need to take to protect your employees from harassment is key. And actually, lots of the same things that we might have been talking about with the new duty on sexual harassment will likely apply in this area too. So we'll need policies in place, we'll need to carry out risk assessments, we need to train our people, we'll need to create a good culture, we'll need reporting processes in place for people to raise these issues, we'll need to track incidents and show that we've show that we've dealt with them. We'll likely need to engage with our suppliers, customers, and whoever else in a way that tries to encourage them to treat our people well. So that's definitely one to look out for. And of course, that's also one that you can be working on now, given that although it might not apply yet, it's not a bad thing to look after your employees in that way. Whistle stop on a few extras. I mentioned interim relief earlier on in respect of fire and rehire. The other thing relating to whistleblowing is that they are extending the definition of a qualifying disclosure, so a disclosure that you make under whistleblowing legislation, to specifically include sexual harassment. Now, in reality, that was possible previously, but they've included it to make it super clear. And of course, interim relief, as I talked about before, that short form hearing where actually the person get protection and potentially their salary paid until the final hearing, if they win at that interim relief hearing, will apply in those instances when it comes to sexual harassment as well. There are also things like collective negotiating bodies for the social care and school support staff, people working in those sectors, industry-wide body composed of various representatives, and the theory is that the Secretary of State would be able to negotiate with them around T's and C's for staff, setting pay rates, that kind of thing. So again, in those sectors, if you're there, it's worth looking at more of the detail on how that might work. And I think the idea is that they're effectively piloting those in those sectors to see whether they will be successful in raising standards, I suppose, is the idea, particularly with regards to pay. Menopause, again, received a lot of attention recently. That said, the bill doesn't go particularly far, other than that employers with more than 250 employees would have to produce and publish menopause action plans, and there'll be penalties for not doing that. But again, we're expecting further consultation on that area in terms of fleshing out the detail of how that might work. And then finally on those changes, something called the Fair Work Agency. So this has been bandied around many times over the years, for quite some time. But essentially, the proposal looks like it would combine some of the powers from existing organisations like HMRC or that kind of organisation, but also extend it. And it would be a body that would enforce certain employee rights without the need for individuals to go to the employment tribunal, which of course is struggling, with resource and timescales and all that kind of thing. And they would be able to say, well, yes, you haven't paid SSP correctly or national minimum wage or holiday pay and that kind of thing, and presumably then force the employers to do that right. The difficulty again will be resource of that agency, and also the skill and aptitude of the people that are making those decisions is clearly important in terms of getting that right, so that employers are not unfairly penalised in those areas. So that's one to look out for. I think quite difficult to achieve, but we'll see how that goes. When is it happening? Consultations are out pretty much on, I think, 4 or 5 areas already. So if you're particularly interested in any of those areas, it's worth looking at. Most change is likely to be 26, although there's been a few areas where there's been some noise about the fact that they might be snuck in this year a little bit earlier. So that's why it's important, I think, to keep up to date on this stuff pretty regularly. What's missing now? Again, since I drafted these slides when the bill first came out, the position's changed a reasonable amount. So I'll try and update you on where we are with these various things, and then I'll hand over to Sally and Lydia for the immigration section. But the right to disconnect was another of those areas that was made quite a bit of, I think, before the election. And this was the proposal that employers wouldn't be able to contact their employees outside of certain working hours. That didn't make the bill, but there is talk, I think, about some sort of statutory code that might be brought in separately that might cover that area. So it's a definite watch this space on that one. Single status of worker, again, not immediately obvious what we mean there, but essentially the government had talked about wanting to simplify employment status, and that's the difference between people who are genuinely self-employed, consultants, those kind of people, workers who are that kind of middle category that have certain rights but not full employee rights, and then the third category of employees that look and smell like employees and have the full rights that we're used to working with. And that has created a whole load of case law, a whole load of issues, a whole load of difficulties for employees and employers over the years because of those different categories, different employment rights, different tax status, that kind of stuff. And they'd like to simplify that. I think they basically decided it was too difficult to do, which it probably is. So it hasn't made the bill, and it's unlikely that we're going to be looking at anything in that area for, I guess, another 4 or 5 years, given the election cycle. So that's not one to worry about for the minute. Reporting ethnicity and disability gaps. Again, I did a LinkedIn update on this week. I think this one didn't make the bill, but actually it looks like there's a separate bill coming on this issue, both reporting those gaps, but also potentially extending equal pay legislation to those areas too. So that's definitely worth keeping an eye on as well. And interestingly, the LinkedIn post generated some good discussion yesterday about whether people think it's a good idea, whether it should go further, whether it should, it's extending something, particularly with regards to the equal pay regime that's very difficult and complicated already, and if there was a better way of doing it. And some people saying we're actually doing this already, even though we don't have to, we're doing it already. So that's quite interesting, and I think one to keep an eye on. Then a review of parental and carers leave didn't make the cut. Again, one that I think the government probably would want to look at, so we'll keep an eye on that. And then the extension of time limit to present a discrimination claim was something that was talked about, and the suggestion was that it would be increased from 3 months as it is now to 6 months. That didn't make the bill, but since then amendments have been tabled which actually have gone even further than that, and the suggestion is that the time that you have as an employee for bringing any claim, not just discrimination claim, but any claim, might well be extended to 6 months. So again, not in the original draft, quite significant in its implications, I think. And again, people have different views as to whether this is a good thing or not. Businesses, I think, will likely think it's going to increase the number of employment tribunal claims that we have. But I think the flip side of that is the suggestion, at least, that it will give more time for an employee and an employer to resolve the situation without the need to bring a claim. I'm not entirely convinced by that, but I think, because I think it will increase the number of claims. But I think definitely a significant change if that one makes it all the way. So that was the whistle-stop headline tour through the kind of key provisions in the Employment Rights Bill. As I say, keep an eye on LinkedIn for our updates as we go. And now I'm going to hand over to Sally and Lydia, who are going to take us through some immigration information. So hopefully we can hear from them.
Right, sorry, just unmuting. Morning, everyone. Thanks, Nick and the team at Actons for partnering with us on this. My name's Sally. I'm the director of the business immigration team here at OTB Legal, and I'm with my colleague Lydia, who is an associate in my team. The focus of mine and Lydia's practice tends to be on sponsor license compliance, and sponsored workers. But obviously, very aware as we are that this is an employment law update, we thought we would cover what all employers have to do in terms of right to work checks, potential pitfalls, and there'll be a bit of an introduction to the new eVisa, just in case any of you haven't come across that. Sorry, Nick, we haven't got access to the slides.
If you guys shout next slide, please. In
The
a
next slide,
Whitty
please,
style,
like Chris Whitty.
I will happily move it on for you.
Thank you. So, an eVisa. An eVisa is an electronic online record of your immigration status. So, since I think April 2022, the old biometric residence permit, which was the little sort of credit card, driving license style identity document, has not been valid for a right to work check. But eVisas have been used by EU nationals and Hong Kong BNO migrants for some time now. Everyone who has limits on their leave to remain, or who's not a British or Irish citizen, should have an eVisa, and they will need to set one up with the UKVI in a UKVI account. They can use their expired biometric residence permits to do that, and we think that they'll still be able to do that until the end of 2025. And a biometric residence permit, we have been told by the Home Office, will still be valid for travel, so to re-enter the UK until the end of March. So if we can move on to the next slide, please. Nick, I was going to call you Chris then. Just back to COVID. So on this slide is just a picture of a biometric residence permit. Some of you may be familiar with them. These should have the conditions of leave on them, the migrant's date of birth, and all of their sort of personal information on a chip inside the biometric residence permit. And it's this that you use to set up your UKVI account. You can do it with the phone. It's supposed to be quite straightforward. But we do kind of help clients with setting up their eVisas, because sometimes the chip's quite difficult to find on your phone. So yeah, it's not without its problems, and some people still have to go for biometric appointments so they can have their biometric information taken. Biometric information is just your fingerprints, your photograph, and an electronic copy of your signature. If we can have the next slide, please, Nick. So as I've said, some employees will already have these eVisas, so EU settlement scheme, EU nationals, and the Hong Kongers. We're supposed to have the eVisa by the 31st. I think that's the wrong date, is it? 21? It was 2024. But as I say, that's been extended for use for travel until March 2025, and then perhaps till the end of the year to set up the eVisa. Can we have the next slide, please? So you need to download the Home Office Immigration ID checking app, which is a little purple app on your phone, and then you can set up the eVisa at the gov.uk, get access to your eVisa account. You confirm your identity using your biometric residence permit and the ID checking app. When you're logging into the system, it's probably useful to have somebody with you. Otherwise, you're having to take a selfie in front of a white background, and sometimes it's quite difficult to get a clear photo unless you're like Mr. Tickle and you've got a massive long hand. So it's quite useful to have someone with you, I think, when you're trying to set up that account. And once you've set up the account, you must have linked your passport to it, so you can use it to travel in and out of the UK. Next slide, please. So you will still be able to use your BRP until 2025 to set up that eVisa account. I think we've envisaged that there will be some problems, particularly with more vulnerable groups in setting up the eVisa. So elderly people, people who lose their passports abroad maybe, and then they haven't got their passport attached to to the e-visa when they come back in. So I think it's not going to be without its problems, but I would say that the Home Office have been quite good and responsive at dealing with issues on e-visas. There's a dedicated email address, and they have been really responsive in dealing with any issues, any mistakes in the name and things on e-visas. If you don't have an e-visa, the kind of hostile environment is going to kick back in, and you're going to find it very difficult to prove your right to work without that share code, and you're going to find it very difficult to rent a property. And I suspect this will be extended out to other areas as well in terms of DVLA, bank accounts, and all of those kind of things. Next slide, please, Nic. Oh, I'm going to pass over to Lydia to do the right to work checks.
Okay.
Thank you.
So I am very briefly going to run through how with these new e-visas you do a right to work check. I'll also start with a quick reminder as to why we do right to work checks. So it's obviously, I'm sure you all know, not lawful to employ someone who does not have the right to work in the United Kingdom. The civil penalties for being found employing someone who does not have the right to work increased markedly in February last year. So they've gone up to 45 grand potentially for a first offence and 60 grand for a follow-on offence. So it is increasingly costly and also potentially quite embarrassing to be found by the Home Office to be employing someone who does not have the right to work. However, if you carry out a valid right to work check on someone before you employ them, that gives you what we call a statutory excuse. So it's kind of like a defence, which will reduce your penalty to nothing. And that is why it is very, very important that you carry out your valid right to work checks and that you always conduct the first check before someone starts employment. And obviously follow-up checks need to be done in time. So obviously up until 2022, the biometric residence permits that we've been looking at were considered a valid right to work document. They stopped being a valid right to work document in April 2022. However, practical real world experience is that I think I've come across a lot of employers who are still using maybe outdated checklists, and we're still accepting biometric residence permits until much more recently. And I'm also mindful that there may well be people who simply haven't needed to use this particular system before because it just hasn't cropped up in your particular business, in your particular setting. So going forward, in order to do a right to work check for someone who has a visa, essentially someone with limited leave to remain or indefinite leave to remain, you will need to start off by getting a share code from the employee. They generate the share code themselves using the link that's provided. It should begin with the letter W. That's how you know it's a right to work check and not, for instance, a right to rent check. And they can either give you the code themselves or they can ask the online system to email the code to you directly. Once you get that share code, you need to use it yourself on the employer side of the system to carry out the right to work check. What you can't do is get the employee into the office, get them to log into their e-visa and just look over their shoulder. That's not enough. You need to use the share code to carry a check yourself. You should always be doing the checks with the person either there with you in the room or on a video call. And that's because when you put the share code in, it will show you a summary of the person's immigration status. It will show you a big picture of their face, big photograph, and it will also show you what conditions they have on their leave. And you will be expected to obviously compare the person who is sat there with you with the photograph to make sure that it's the right person. And it is also very important to check if they have any conditions attached to their work, which we'll be covering in a bit more detail in a moment. So can you just have the next slide, please, Nic? Last step, obviously, is to keep evidence that you carried out the check. Now, with these new online checks, this is actually nice and easy. You can download a copy of the summary very easily on the system. It will contain the date that the check was carried out, which is really nice. It will contain the name of the employer who carried out the check. So it does, in some ways, simplify the system compared to the old thing of having to copy BRPs and write declarations on them. You just need to then save it securely for as long as the person's employed, and then another 2 years. You can either save it electronically, as long as you know where you've saved it and you can access it quickly and easily if needed. You can also print it off, or you could do both of those things, entirely up to you. It goes without saying that if someone does have limited leave to remain, if they've got a visa that's going to expire, you need to make a note of that, and you need to make sure that you're carrying out follow-up checks well in advance of that visa expiry date, to make sure that you keep a continuous statutory defence from your the checks that you've carried out. So I can just have the next slide. Okay. This eVisa system, although it's been mooted since 2022, it has been a bit of a rush at the end by the Home Office getting this all sorted out, and there has been various stuff in the press, I'm sure you'll have seen, about issues with this system. I certainly have experienced problems with it. Typical problems are that people they log on and there's a technical problem and they just can't generate a share code. It just doesn't work. I've also come across cases where, for example, people log in, but the information that's showing in relation to their visa is just wrong. It's provably inaccurate. There maybe have been a typo on the Home Office side, goodness knows what. If that happens, if there is a technical reason why you can't use this system, as a backup, you can use the old employer checking service. This is now quite confusing because we have two separate online checking systems, but this one is called the employer checking service. Again, you can follow the link that I've provided there to make sure you're using the right one. It will ask you to enter some details about the employee, which it will send off to the Home Office. And essentially, it's a manual check about the Home Office side. They will check the person's record, and assuming that they have, that the person does have the right to work, they will, within a few days, send you something called a positive verification notice. That will confirm that the person has the right to work. It will set out any limitations on that right to work, and it will be valid for 6 months. If you get a PVN, positive verification notice, you need to keep a copy of the passport that goes with it, with the usual declaration on the bottom about it being a true likeness of the individual. But that then gives you 6 months for the employee to work with the Home Office to try and sort out any technical or typos that appear on their eVisa, so that you can then rerun the right to work check and keep your statutory defence for as long as they are employed. Now, the next slide, please. Okay, so what I'm going to do now, rather than tell everyone how to do every single right to work check for every type of worker, I'm just going to pick up on 2 or 3 recent changes to the employer guidance on right to work checks, just to highlight things where there are some new additional obligations that it's worth being aware of. I would start off by saying that the right to work isn't just a binary, isn't a binary thing. It's not that people have the right to work or they don't. A lot of migrant workers will have limitations on the type of work they can do. So most people with work visas will be sponsored to do a particular job for a particular employer, and they need to remain in that job. But various types of migrant workers are permitted to do what we call supplementary work. So in most cases, that is a maximum of 20 hours per week. For those on skilled worker visas, they can now do an additional 20 hours in any type of job that could potentially be sponsored. So that normally is a role that the Home Office has deemed to be sufficiently skilled. If you're not sure if a role falls within that category, you can check the immigration rules in Appendix Skilled Occupations, which has a big list of the types of job that are eligible for sponsorship. You can also sponsor people in a role that's on what's called the immigration salary list. Those are jobs that the Home Office accept are in shortage occupation, and therefore they're happy for people to do those jobs. Good example is care workers and senior care workers are both on the immigration salary list. Next slide, please. So other work types of visa where you can do supplementary work are listed on the screen. That's most types of sponsored visa. Slight difference with these. Workers in these categories can work in a role that's on the immigration salary list, or basically the same type as the job as they're doing for their sponsor. So it's more limited in what they can do. And so it really would be down to you as the employer doing the right to work check to find out what they do for their main employer and make sure that the job you're offering them is the same. And that is where these changes to the guidance start to kick in really for you. And the next slide, please. Okay. It's important to understand that any supplementary work that migrant workers do must be outside their hours of their main sponsored employment, and they must still be in their main sponsored role. If they leave the job that they've been sponsored to do, their work isn't supplementary to anything. So if you're employing someone to do supplementary work, you would have to stop employing them if you find out that they're no longer in their role. The key change that has come in is that where you are employing someone who's sponsored and they're doing their 20 hours supplementary work for you, you now need to get evidence to satisfy yourself that they are meeting the work conditions of their visa. So what the guidance would suggest is that you ask for a letter from the sponsor to confirm the job that they're doing, what their standard working hours are, what's called their standard occupation code is, and whether their job is on the immigration salary list. That is not specified as a mandatory document, so it is possible that you may think of another combination of documents that would satisfy you that the person you're employing is in compliance with their work conditions on their visa. But increasingly, this change is aimed to increase your role as policeman, I guess, of the immigration system and ensure that the people you are employing are in compliance with the terms of their leave. It is also important to understand that a right to work check is great, but if you find out that someone has lost the right to work, so if you were to find out, for example, that someone's resigned or has been dismissed from their main job and you're employing them for their 20 hours supplementary, you would need to speak to Nic Elliott about how to cease employing that person. If someone no longer has the right to work and you know that, then whatever statutory excuse you've gained from carrying out a right to work check is lost. And it is a criminal offence to employ someone when you know that they don't have the right to work. So important to keep that in mind. Have my next slide, please. Okay, students I've just included because they've got a similar rule. They have limits on the number of hours they can work in term time. Typically, it's 20 hours in term time, full time in the holidays. You need to get evidence from the university as to those term dates, in addition to doing your getting your download from the share code. So you need both of those things. Other strange little facts for students. They're not allowed to work as entertainers or as professional sports people. So if you were thinking of employing any students in those roles, please don't. There is also a strange condition for students, which says that they are not permitted to fill a full-time permanent vacancy unless they have applied for a graduate visa or a skilled worker visa. There's no further explanation really within the guidance as to what the Home Office mean by a full-time permanent vacancy. It tends to become relevant only when when students have finished their course and they're starting to go out and look for work. practical ways you can deal with this. Initially have them just working part-time hours, or have them in temporary roles. Either of those potentially are perfectly good options, just to bridge them until they are in a position to apply for instance, a graduate or a skilled worker visa, in order to stay in the longer term. Next slide, please, which I think is my last one. Okay, so this is one of the few cases where what you need to do has become easier. So I'm sure we all remember the happy days of the EU settlement scheme and the withdrawal agreement. Basically, EU nationals and their families who were here have been living in the UK for 5 years at the date that we left the EU, got settled status. They were allowed to stay forever. They had to make an application in order to get that, but as long as they did that, they were fine. EU nationals who had not lived here for 5 years but were living here at the date that we left the European Union were given pre-settled status. The idea at the time being that once they'd clocked up their 5 years, they would make a fresh application to top up their leave to the sort of full fat, if you like, full settled status. Following some litigation that has been taken through the courts, it has been found that it's not lawful for the government to require people with pre-settled status to have to make a further application. What that means is that if you're confident that you've done a full valid right to work check for someone with pre-settled status, you do not necessarily have to do a follow-up check. They should, and the Home Office are starting to kind of upgrade people automatically. Again, the only caveat to that is that if you know that someone has lost their pre-settled status or isn't going to get upgraded to full settled status, you need to take some advice on that and consider whether you can still employ them. But by and large, reduced need for follow-up checks for this one small group of people. And that's the end. I think we just got a thank you slide at the end.
I think there are a few questions,
Thank you, guys. Yes, so I'm very happy for people to pop questions in the chat, and in fact I suggested that happen, and we've got one for you guys so far. You'd be pleased to hear. So the question is, would freelance work like delivery drivers classify as supplementary work?
So for your skilled workers, for example, you would struggle with delivery drivers, things like Deliveroo, that sort of thing, because it's not sufficiently skilled. So it wouldn't fall within those 3 tables. Skilled workers can be self-employed for their supplementary work, and some skilled workers do like consultancy, for example, for a few hours a week as a top-up. So that's fine, but doing delivery driving in particular, I think, would be problematic for that reason.
Yep, makes sense. Any other questions? So Zoe's got a hand up. So I don't know whether Zoe can unmute if you would like to ask a question.
Yeah, sorry, it won't let me use the chat function for some reason.
No problem.
Yeah, I've got a question around student visas. So I've got a student who's limited to 20 hours in term time. They've actually completed their course, and I've seen the evidence they have completed their course.
Yeah.
They've applied for graduate, obviously changed their work visa, but that's not actually come through yet. So can they work full time, or do we need to wait until confirmation of the change of their visa has taken place?
You would need, once they've submitted the application, they can work full time, but you're going to need to satisfy yourself that that's been done.
Yes, so they've done that, and I have seen the evidence of that. Yes,
that's fine.
Okay.
You can do. The only thing I'd say is that those graduate visas, they come through really pretty quickly.
Yeah. Okay.
Yeah.
Brilliant.
So it's a case of whether you want to
just wait,
do that and then have to do another check in, a few days time when they get their graduate visa, or whether you just, wait what is likely to be really not very long. Okay,
brilliant. Thanks very much.
Excellent. Thanks, Zoe. Any other questions? Either in the chat or anyone who would like to unmute and ask either the OTB guys or me? Okay. Oh, here we go. Oh, I think it's a comment saying I've applied. Ooh, I've lost it. There we go. I've applied for my graduate visa and it's been almost 40 days. So sometimes it does take a bit of time.
Okay,
So
fair
there
enough.
we go. There we go.
Yeah, I mean, yeah, you can't guarantee it, but my general experience is that they come through fairly quickly. I mean, I think the standard processing time, so sort of the deadline they give themselves is 3 weeks.
Okay. Yeah.
Yeah, sometimes there might be, there might be individual issues that can cause it to take longer.
Sometimes there's a problem with the university as well. So the universities are required to block transfer all the data from their foreign national students over to the Home Office. So when people do apply for those graduate visas, the Home Office have that information already. Sometimes that doesn't happen, or somebody's missed off. So I would just check with the university as well to make sure your graduation details have been transferred.
Yeah, great. We do have another question again for you guys. Immigration's clearly the hot topic. The questions are moving. Would being a director and running a business that is different in nature from the primary job be supplementary work if it was limited to less than 20 hours per week?
Depends on the visa that you're on, is the short answer. So if, for example, you're a minister of religion, you would need to be freelancing as a minister of religion. Seems maybe a bit unlikely. Different rules for skilled workers. So we need to have a look, I think, really at exactly what you're doing in order to say for certain.
Yep. Then another question about how long you should keep right to work data after employment ends.
2 years.
2 years.
Okay. And no longer than that?
That's what the guidance sets out. After that, obviously, it's a case of whether you feel that you can justify it in line with GDPR and all the rest.
Yep. Fine. Great. More questions coming. Is it still okay to check passports on Zoom?
Good question.
I think they got rid of that after COVID.
I think they did after COVID as well.
There's a couple of, so you can still manually check passports, but it has to be done, I think, in person now. Or the Home Office have these identity.
Yeah, there's these computer systems that you can use.
It's quite expensive. So, I mean, we can get you the details. There's quite a few providers that will check kind of British and Irish passports for people now, but it's not a cheap service. So I would just get the person in person and check it with them.
Yeah, the key thing I think to understand with it is that if the Home Office ultimately looks at the passport and thinks it's fake, they're going to ask, would it have been reasonably obvious to the man on the street that this was maybe not a genuine document? And that's much more difficult to do on Zoom, and that's why really I think they want you looking at the original.
Yeah.
Okay, great. And then one other question, one final one.
They're going to have a setback.
So if the sponsored job ends and the worker fails to find another job, what options remain if the previous visa was a student visa? Can they still qualify for PSW?
So you don't need a job for what's called a graduate visa. They used to be called post-study work visas back in the day. But the current iteration is called a graduate visa. As long as a student is in an eligible course and completes it successfully, they should be able to switch into the graduate visa. You don't need a job for the graduate visa. It's quite a nice visa in that way. It's quite flexible for the person who holds it. And it can be quite nice for employers because they can recruit someone, see if they're a good fit without having to go through the rigmarole of sponsoring them right at the beginning.
You can't. I don't think you can go back to it though. If you've got skilled, if you switch from student to skilled work and then lose your skilled worker visa, you can't go back to the graduate visa. So you have to switch from student to graduate, and you can't get the graduate if you leave the UK either.
Yeah, it's a one and done.
Okay. Brilliant. Great, and I think we're going to have to call it there. I was tempted to ask you what entertainer includes when it comes to students, but that's maybe a conversation for another time.
Yes.
So thank you so much, Sally and Lydia, for joining us on this. And clearly there's lots of interest in the immigration side of things, so hopefully that was really useful for everyone on the webinar. It certainly was for me. And yeah, we look forward to seeing everybody next time. If you do need any further assistance, obviously reach out to me, Sally, or Lydia. Again, you can get our contact details there on the QR codes. And as we've said, a copy of the recording, sounds a bit old-fashioned, doesn't it? Will be sent to you after the webinar, so you have all the details there as well. Look forward to seeing everybody next time. Thanks very much.
Thanks, everyone. Thanks, Nick.